a constitutional lawyer and an individual who's also been actively involved in this conversation of the impeachment of the former deputy president, now at the level of the courts. And a new twist, arises from what was determined by the courts. And here we are picking it up from what Dudley Ochieng then says, that the main interest, on behalf of his client, or the client, would be that, the CJ then comes on board to constitute another bench. What if the CJ then proceeds to pick the very same names that were constituted by the DCJ? Then what happens?
It is, there is nothing that prevents the Honorable the Chief Justice from picking those three judges to continue with the cases.
Right.
But remember, the impeachment of the Deputy Chief Justice, of the Deputy President,
yes,
was a matter of momentous public interest and significant controversy. Since the Chief Justice is supposed to act prudently and ensuring that all sides in the debate are comfortable. Remember, in the judgment of the Court of Appeal that we are talking about, there was an application for the recusal of those three judges, which was very hotly contested in the glare of public television, live television. So there were very strong feelings when the matter was being argued. And since we have more than 60 High Court judges, if petitioners, even if they have been told, you see, the standards, the threshold for disqualification, unfortunately, is very high. And since the Court of Appeal said that threshold was not reached, that is not to say that there is no concern on the part of the petitioners. Because remember that part of the rules of natural justice and Article 50 is that cases should be heard as much as possible by judges who enjoys the confidence of everyone. So from the word go, even if now he was to pick the same people, it would start from the premise that the petitioners have no confidence, which they have expressed. So now that there is an opportunity to ensure, and there was even urging that there should even be more than three, because we've had cases of lesser significance, where we have had 5 judges. In my view, those applications that were made, including one that I'm representing some of the clients, and I was also involved directly in the argument of this particular case, it would be very important that the Chief Justice views it broadly, even if there is nothing that stops her from reappointing those ones. Because, and the major reason would not be anything curtailing her power, but the interest, the principle of law, that everybody should enjoy confidence. If you see, if you have only 5 judges in Kenya, it's a different issue. But you have more than 70 High Court judges. There would be no reason for you to stick with those 3 when there is very strong feeling, whether they are right or wrong. You know, sometimes they say that I need not be right, but if I say, I have no confidence in you. In fact, ordinarily, even our traditional justice system, do you know what used to be the first thing that is among the Kikuyu community? When you went before the elders, before now the elders who will decide the case would sit, they would ask, is any of you objecting to any of these elders? If somebody said, I object, that person was automatically removed. And you did not even have to give reasons. For the simple reason that an objections need even to be subjective. But you see, in the common law judicial system, it needs to be objective, you see. And the standards are very high, because the standards are not the person feeling lack of confidence. The standards are another person out there, whether presented with the same facts, would have your own view. That may be at an objective level, but it doesn't remove the subjectivity. That even if everybody else feels confidence in you, and I don't, I'm the litigant.
And that with the understanding of just how, this case holds such a huge magnitude.
Yes.
That the very same judges overlooked the essence of looking at what the Constitution dictates as to who is to pick or to impanel or to constitute this 3-judge bench, and allowed for the DCJ to take up the challenge, in as much as we acknowledge that the CJ was actually not in the country. Would it have been done different? Perhaps would it have landed them where it is that it has landed them today?
Yes, of course, two things. Of course, first of all, the easier one is this, that as the Court of Appeal noted, during this time when the Pope dies, 2 minutes later, we know, there was no indication that the Chief Justice could not be reached and to be posed. Okay. An urgent matter has been filed. Okay. And given the urgency of the matter, we need to constitute a bench so that this matter can be heard in the shortest time possible.
What would that have meant? Travel back home or just pronounce from where you are?
Calling. He knows all the judges. Okay. And I'm sure she has an iPad with all the relevant details. Okay. She could even have reappointed the same people. Right. So that was open. But where the public does not understand, that was not the real issue at that particular time. The real issue at that particular time is that on a Friday, a day like today, 2 orders were given. On a I believe in the morning of Friday and in the evening of the same day. One of the orders was to stay the decision of the Senate to impeach, that was issued in Nairobi, to impeach the deputy president. The other one that was issued in Kerugoya was to stop the swearing in of Honorable Kindiki, that was issued in the evening. Okay. Now, all these cases were referred to the Honorable the Chief Justice. In a normal course of business, we have never, as lawyers who practice in that division, constitutional division, had a situation where the Chief Justice acted even within 96 hours. Now, what happened, and that is where the source of all these problems were, is that the following day on a Saturday, about less than 12 hours after these decisions were made, the Deputy Chief Justice decided to make that decision on a Saturday. Okay. So that the question that arose, first of all, from the petition, is it is important we say here, was the Deputy Chief Justice trying to do exactly what has happened in Parliament. You know, the deputy president was being removed like it was an emergency. Like
was it not an emergency?
It was
and
not
perhaps
an emergency.
Even for Rigathi Gachagua himself, so that they get to understand how do we block the swearing in of Kindiki Kithure, which actually did not happen.
Yes, precisely. You know, there was already an order that was issued. So the hurry now that came, and it is important the public to understand that, the hurry that came, remember, let me take you a little back a little bit. Right. Remember the hurry that was there before the National Assembly. The deputy president said he was unwell. They could not even adjourn, though the Constitution allowed some time. Yeah. That is at the Senate. When it went now before the High Court...
But they adjourned for some hours, you remember, waiting.
Adjournment has never meant hours.
Okay, it means until the party, the party
is reasonable time. Okay. And reasonable time when you say you are unwell.
All right.
Because people get sick every day. If they say that you are unwell even here, TV47, I believe they will not say you come in the evening and at 1 you have just said you're unwell. Okay. You get? So it's reasonable. But you see, there was a hurry. That one is a matter of public record. Right. There was a hurry to make all these decisions in a hurry. So that even when now the High Court issues order under certificate of urgency to stop this process of impeachment from going on, when the Chief Justice, Deputy Chief Justice, acted with the same hurry, like the way the High Court, the National Assembly and the Senate had acted, the petitioners led an element of collusion. Okay. That you could have been part of the team that is trying to hurry up the removal of the deputy president from office. Okay. That was a real problem. Okay. And that is why it was objected to. You know, people may not understand exactly why was it a big deal. The big deal was Now, you could not even wait for Chief Justice was to come on Tuesday, which was within the 4 or more days period that we've talked about. So, from the word go, therefore, there was everything wrong from the point of view of the petitioners.
Right.
That how does an order get given? And then the matter was even called on a Saturday for some mention. You see? So the issue, because it is not normal for a court, and this was not an injunction, to ensure that everything is being speeded up in a matter that had already aggrieved our clients about the speed with which this matter was not being dealt with. It is important I mention that the president, after the decision was made late in the night, in the morning when he gave the name of Honorable Kindiki as his appointed deputy president, the Constitution says within 60 days, Parliament shall consider the issue. The same Constitution says that the president was required to get from help, whether he has paid the fees, anti-corruption,
all this,
to get everybody to approve of him. So that since this was done at midnight, so was all these clearances given at night, knowing that public officers don't work at night?
This was his interior CS. This was his
AM,
interior CS. Perhaps he had the...
No, the law is the law.
The law is the law. It must be followed.
It must be followed.
It does not matter.
You must have confirmation. You can be appointed 6 months previously, but then allegations have been made after that.
Fair enough. Okay, I want us
disqualify you.
Okay, I want us to take...
So it was that hurry that had a problem.
So as it stands, the question is status quo ante, or what then happens? But allow us to take a short break, and then we come back to that very note. Okay, after this break.